Okay, so he started recording. Um, I referred to them as safety nets, but the biggest thing was they were safety nets for the economy. Just like everything else we talked about last chapter, these employment laws started to become of the vogue sort of in the Great Depression. And once again, just going through economically what happened when the Great Depression started, certain industries started having hard times. They stopped having the ability to employ their people. So how do you save money when business has a downturn? You let go of your employees. You don't need your employees anymore. Tell them we don't need your services. Get out, and you stop paying them. As a company, it's a way for you to cut your losses. You no longer have to worry about paying those people. So it's a way for you to protect your company. Problem is those people are now out of work and they have no money to spend because there's nothing out there to protect them. They end up out of work, not able to pay their bills. So the people that they would ordinarily be paying using the money they made at the job, those people are no longer getting paid. So they have to start cutting back on what they spend. And so every time we go through a cycle here, the spiral tends to get bigger or smaller if you look at it. If you look at it as the economy being this big thing, and every time we do a cycle like that, it contracts because more and more people go out of work. And as they go out of work, it affects other people's job and they go out of work, and it affects more people's jobs and they go out of work. So it caused the economy to shrink dramatically. So some of these safety nets are not only safety nets for the workers, but these are things that are out there to safeguard the health and vitality of our economy. Okay, so if we go into a bit of a recession and a lot of people lose their jobs, well, we just have a lot of people on unemployment. We just went through a period like that. So at the very beginning of the pandemic, we had a lot of closures. A lot of state governments decided to close down certain types of businesses in order to try and limit exposure to the coronavirus. And as a result, there were a lot of people that were out of work. So what did the government do? Well, the government paid unemployment to the people who lost their jobs because of the pandemic. Actually, it was more than just a safety net. It became a stimulus thing because the government wasn't enforcing a lot of the standards for who was allowed to collect unemployment. And then beyond that, they also put in what was an additional $300 a week benefit that you could receive if you were getting unemployment. So there were a lot of people that were theoretically making more money being unemployed than they were making when they were working. So that kept the economy kind of moving. Yes, we had a bit of a retraction in the economy, but I think the economy has pretty much recovered. The stock market has done pretty well. People went back to work that wanted to go back to work. Now we have this labor shortage thing going on because people don't want to go back to jobs that are crap jobs anymore, or they don't want to go back into dangerous jobs because of the pandemic, whatever. But the safety net did what it was supposed to. The massive unemployment did not cause the economy to completely derail, and it was able to recover once people went back to work. So it's an economic safety net that protects the economy. Okay, it also provides benefits for individual people, but the big thing out there, and if you want to say that it's a welfare program for the good and welfare of people, fine, but it has the added effect of being a safety net for the economy. So the things we're going to talk about in this chapter are unemployment, workers' compensation, Social Security, and retirement. And this is going to take more than one day to go through this chapter, okay? There's a lot of concepts here. Okay, so the first one is unemployment. Unemployment compensation, you can ask yourself as to whether this is a governmental program or is this some sort of a insurance policy, insurance program. Just checking messages here. It doesn't matter. Unemployment is a state program. Okay. Each state has its own, Autumn's getting back in. Each state has its own unemployment system, its own unemployment benefits, its own unemployment program. Okay. So looking at it from that point of view, what's the federal government have to do with any of this? Well, although it's mostly a state program, there is a federal program that exists also. There is unemployment, state unemployment, and there is federal unemployment. Now, if you are laid off from your job, and we'll talk about what is required for you to collect, but suppose you are eligible to collect unemployment because of the way that you lost your job, you receive state benefits. Okay, now we normally talk about what goes on at the federal level, but there is no federal unemployment benefit. Okay, that's kind of a twist. You have to be careful here. There is a federal unemployment system, but you don't apply for state benefits and apply for federal benefits. Everything is run through your state program. If you're an employer, you pay unemployment tax to both the state and to the federal government. The state program is by far the most important to the individuals. I would assume just because of sheer size, the federal program has probably got more money than any particular individual state. But I think if you add all the states together, they would dwarf the federal program. So what happens is you lose your job and you want to apply for unemployment benefits. In order to qualify for unemployment benefits, you need to have lost your job through no fault of your own. Okay, I have to repeat that. It can't be your fault that you're unemployed. It has to be your employer's decision. Okay. Reduction in workforce, RIF, reduction in force is one of the things we talk about quite a bit. This is what people will talk about. Oh, I got laid off. What's that mean? Well, it means I lost my job. You mean you got fired? No, I didn't get fired. I got laid off. Why aren't you working? Because the employer doesn't have any work for me anymore. I would be working there if they had work, but they have run out of work. They manufacture widgets and they are well above pace, well ahead of what they need to produce to have widgets for the next 2 months. So they don't need me to come into work for a while because they don't need my services because they already have all the widgets they need. Did I lose my job because of something I did? No. I lost my job because my employer no longer needed my services, and so that they can save money and try to stay as profitable as possible, they let me go. It was a reduction in force, an RIF. Okay, I lost my job through no fault of my own. This was an economic decision on the part of the employer. I should qualify for unemployment benefits. Now, eligibility for unemployment comes from a couple of different places. First thing is you have to qualify, as I was just saying, based on how you were separated from your employment. What if I was let go from my job because I was constantly late? Well, wait a minute, it's not my fault. I have to rely on the buses to get into work, and the bus service is very erratic and not very reliable. So I was late for work 3 times, and my employer told me, hey, we need you to be here on time. If you are late for work one more time, we're going to have to fire you because we need to have reliability in our employees. And it was the bus. It wasn't my fault. The bus that I was on just didn't keep its schedule. It got stuck in the snow or whatever the excuse is. I went into work. That was my 4th late, and they fired me. It's not my fault. Sorry, I'm sorry, it is. Okay. One of the only ways, other than if you decide to leave on your own, if I just decide I'm fed up with my job and I quit, I can't collect unemployment because I decided to not work, not my employer. Okay. But one of the big ways that you fail to qualify under the way that you are terminated from your job is something called willful misconduct. Okay, now I do want to point one thing out while we're here talking about losing your job. You've heard me talk about the fact that we have what's called at-will employment. In most states, we have at-will employment, which means that the company can fire you from your job for any reason or no reason, as long as it's not an illegal reason. That's the way that I state it, okay? You can't fire me because I'm Catholic. You can't fire me because I'm over 40 years old. You can't fire me because I am white. You can't fire me, you know, whatever. If I'm being discriminated against in one of the suspect classifications, ethnicity, race, religion, age, gender, those types of things. If I'm being let go from my job for one of those reasons, that's an illegal reason, and I shouldn't be let go. Okay, and it's illegal. But I come into work today and I have on brown shoes. My boss goes, I hate brown shoes. And the fact that you're wearing brown shoes tells me that I can't trust your judgment. So I have to let you go. I can't work with somebody who even owns a pair of brown shoes. Is that a legal reason to fire me? Yes, it is. It's not an illegal reason. They weren't discriminating against me based on one of the suspect classifications. And since it's an at-will employment state, can my boss fire me for wearing brown shoes? I can be fired for any reason or no reason, as long as it's not illegal. Well, there's nothing illegal about firing me for wearing brown shoes. So yes, I would lose my job. The question as to whether I'm entitled to unemployment benefits is an entirely different question. My boss can fire me. I can lose my job. I have no right to my job. So if my boss says, you know what, you're out of here. I don't like you. I don't like the look at your face. I don't like the way you talk to me. I don't like the sound of your voice. You're out of here. That's legal. Can I collect unemployment? That's a whole different question. Okay. Did I lose my job because of something I did wrong? Well, I wore brown shoes. Is that something that's wrong? Not really. Okay, so losing your job because of something you did, generally we refer to that as willful misconduct. So if you are fired for willful misconduct, then the employer will not be responsible to pay for unemployment benefits. Willful misconduct means there was a rule at the place of employment. I knew what the employment rule was. I broke the rule knowingly. I was probably warned, hey, you broke a rule, don't do it again or you're going to be fired. I broke the rule again and I was fired. That's willful misconduct, okay? I've been late 3 times in this last fiscal quarter. I get called into my boss's office. Hey, we need people here on time because we're a team here. We all have to be here working together. What's the deal? Why are you always late? I'm always late because I have this problem with the buses. The bus can't get me here in time because it's erratic and not reliable. Is there an earlier bus that you can take? Well, yeah, there's a bus that's about an hour earlier, but then I'd get here an hour too early. Well, but if you take the bus that's supposed to get you here right on time, there's a real good chance you're going to be late. Yes. All right. Well, John, here's the thing. You've been late 3 times. We don't tolerate being late in this position. If you are late one more time, we're going to let you go because we need people who can get here on time. What are my choices? My choices are to get a car so I can drive in and be on time whenever I want to be, right? Or to take the earlier bus to make sure that I'm on time. So if I don't do one of those 2 things and I continue to take the bus that is dangerous and I end up late one more time, my boss finds out that I was late. He calls me into his office and he fires me. Did I know there was a rule? Yes. Was I warned that if I broke the rule again, I would be fired? Yes. Did I break the rule? Yes. That's willful misconduct. Usually willful misconduct is going to be on things like attendance, being late, not coming to work at all, absences, those types of things. If a company has a policy with regards to attendance, then If you don't meet those requirements, they're going to fire you. And if you know about them, then it's willful misconduct and you won't collect unemployment. Okay, so from the point of view of knowing that a rule exists, from the employer's standpoint, what's the best way to make sure that your employees know what all the rules are? Anybody want to take a guess at that? Holly, what's the best way to make sure your employees know what all the rules are?
An employee handbook.
That's exactly right. Most employers will try to put all of their rules in an employee handbook. So when you're going through the process of hiring that employee and onboarding them, so to speak, so that they are going to become one of your employees, one of the things that should happen in their orientation is you should give them a copy of the employee handbook with instructions to read it. You have them sign a receipt that they received the handbook from you and that they were I don't want to say ordered, but it was, they were told that they should read the book so that they're familiar with what all the rules are. Okay, so understand that I'm teaching this class from both points of view, from the point of view of the employee as well as the point of view of the employer. So how do you protect yourself from bad unemployment claims? Have an employee handbook. That way everybody knows what the rule is. And then what you have to do as an employer is you have to enforce the rules. If you have a rule that says you're only allowed to be late 3 times in a fiscal quarter, and you have somebody that is late 3 times, you have to call them into your office and you have to tell them one more late, one more tardy will result in your termination. You have to do that. If you have a couple of people that you don't enforce the rule against, oh, that's Bill over there. He's one of the guys, you know, he gets in, he comes in when he comes in. And, we don't have a big problem with that. But, oh, there's Sally over there. Got to make sure she gets in here on time. Well, then you're not enforcing the rules properly. Okay. If you have a rule, enforce it against everybody. Hold everybody to the proper standard. If you start picking and choosing how you enforce your rules, then you're going to have problems in the unemployment field because somebody's going to say, hey, wait a minute, they didn't enforce that against so-and-so. Why am I being fired? One of the things that I used to do in my practice, the legal profession has what we refer to as pro bono work, which means for free. And when I was a member of the Erie County Bar Association, we would have a pro bono network. You would put your name in and tell the Bar Association what type of work you were willing to do. And they would send you pro bono cases to handle. So you would be able to do your part for the good of society, you know, do some free work. And one of the areas that I did free work in for a while was unemployment compensation. I would do appeals for people who had applied for unemployment when they lost their job and the employer objected to them receiving unemployment, so they lost the unemployment and had to appeal the decision. I would handle the appeals in front of the appeal referee. I had one case where it was a woman who worked at a deli at a grocery store. And one of the things that the grocery store allowed the people to do, especially the people who were working in the deli, they tended to not have the opportunity to, they didn't have the staffing, so they didn't have the opportunity to give them legitimate breaks for their lunch during their shift. So what they would allow them to do is they would allow them to take food from the deli and just go in the back and take like 15 minutes or so paid and eat the food that they had taken from the deli. And it was supposed to be, you know, below a certain dollar value. They couldn't take thousands of dollars worth of food back there and eat it, but, you know, maybe about $8 worth of something from the deli they could take in the back, eat it, not have to punch out, not have to pay for the food, and then get back to work. Well, this one person, for whatever reason, she had irritated the management of the company, and she was working behind the deli, and she didn't even get a chance to do that. It was just so busy. They didn't have complete lack of staffing. They didn't have anybody there that could relieve her. So she worked her entire 8-hour shift without any breaks whatsoever, not going to the bathroom, not taking a lunch break. And what she did was, at the end of her 8-hour shift, she took some broccoli salad and put it into a container that you were required to weigh it out so that you could be priced out, so you could prove that it was below the approved dollar value of, I think it was like $8. And she took it home with her. Now, they fired her for theft, saying that she had stolen the broccoli salad. And when I talked, and she applied for unemployment, she was originally granted unemployment, but then the company said, no, we fired her for theft, so she shouldn't collect. So they stopped her unemployment, and she had to appeal the decision. So when we went in front of the referee, I had asked her, is this something that is usual, that if you don't get your break properly for your lunch, that you just package yourself up for the food and you take it with you at the end of your shift when you go home? And she said, oh yeah, that happens all the time. These are the other people that work at the deli, and it's happened to each and every one of them, and none of them were fired. So I had one of those employees come to the hearing, and I asked that specifically. Have you ever done this before, where your shift, you didn't have any relief and you didn't have the opportunity to take any kind of a break, and you took your allowed lunch allowance, you took it and packed it up and took it home with you? Well, yeah, that happens all the time, she said. And I asked how many people that happens to. She says, oh, basically it happens to just about everybody. Everybody has that kind of a shift on occasion. And so you just package it up, and you have it weighed, you make sure that it's under the dollar value, and you get to take it home for free. Nobody else got fired, just the woman that I was representing. So like I said, they were firing her for doing something that they said was against the rules, but they didn't enforce that against anybody else. Is it a rule if you selectively enforce it? No, it's not a rule. Okay, so you have to have the rules. It has to be in your employee handbook. The employees have to have a copy of the handbook. They have to know the rules are in there, and then you have to enforce the rules, not selectively, but you have to enforce them properly. Okay, that's how you get willful misconduct. Somebody knows there is a rule, and they purposely break the rule, knowing that there's an opportunity for them to lose their job. Okay. Now, I said you had to qualify for unemployment under two different standards. One was how you were separated from service. The other one is an economic or financial requirement. And I can't tell you the exact number in Pennsylvania, but basically you have to have a certain amount of work in with that employer before you qualify financially to receive unemployment. See, the thing is that, and I'll talk about how it's funded through taxes in a minute, but the way that it was in Pennsylvania, and I believe this is probably still true, you don't get credit for the quarter that you are in when you're separated for service. So you have to look back financially one quarter prior to the quarter in which you were let go. So if you were let go in, say, November, which is the fourth quarter of the year, any earnings that you had in that fourth quarter are not counted. We would have to go back to the third quarter, which is one quarter prior, and then we would go back a year. So you skip the quarter that you're in, and then you start looking for financial eligibility 1 quarter back, 2 quarters back, 3 quarters back, 4 quarters back. And then you look at the amount of wages that person had, and if they met the financial earnings requirements, that they had enough earnings in that period of time, then they would be deemed to be financially eligible, or eligible based on the dollars and cents part of it. Okay, so if you were a new employee and you didn't have any earnings in the prior quarter or anything in the prior year to that, you wouldn't qualify for unemployment because you didn't have the proper earnings. Okay. Continuing along, the amount of your benefit is going to be determined by the amount of your earnings. There's a formula. Once again, don't ask me for the formula. I've never had to worry about it. The state does a good job of actually calculating those things out properly. So I've never fought with the state over how they calculated the benefit. But it's some sort of a formula that they put into what your earnings were. Excuse me. And then there's a maximum that you're allowed to receive. The whole idea here is this is a safety net. This is not supposed to replace all of your earnings. It's to keep you from going broke. It's not to help you live a good life while you're unemployed. They do want to encourage you to look for work so that you're not on unemployment forever. It doesn't last forever. There is a limit to how long you can collect. But the big thing is that there's a maximum that you're going to collect, and it's not going to make your life completely, oh, this is great. You know, of course, during the pandemic, when they added that extra $300 a week stimulus in there were a lot of people that were actually making more money on unemployment than they were working. So they enjoyed being unemployed. The whole idea is that you're actually supposed to get less than you're normally used to making, so that although you're not going to be financially devastated, you're not going to be comfortable enough to just say, oh, I'm happy being unemployed. You know, that's not what we want to have happen here. I should probably see what the book has to say, because that was all out of particular experience of how I do things. Unemployment compensation, the definition is benefits paid to employees out of work through no fault of their own, and who are available and suitable, who are available for suitable work if and when it becomes available. Willful misconduct definition, the high level of fault that disqualifies an out-of-work worker from collecting unemployment benefits. The normal amount of unemployment benefits that are available, I believe, is 26 weeks, which is 6 months. In theory, if you are laid off on a reduction in force, and you're told that the company expects to call you back in 3 months, you're not going to spend a whole lot of time looking for a new job. You'll collect your unemployment during those 3 months, and then you'll take your job back when the company says, okay, we're ready to start manufacturing again. We need all of you back. But if you were permanently laid off with no guarantee that you're ever going to get your job back, you're probably going to be looking for work. So 6 months, 26 weeks is a goodly amount of time. It gives you a chance to be able to go out there and actually look for a job without having to worry about starving or your family starving. Okay. In times of high economic crisis, the government can extend the unemployment benefits. They can go from 26 weeks all the way up to 52 weeks, a full year worth of unemployment. Now, this is where the federal unemployment comes in. The states tend to limit their benefits to the first 26 weeks. But like I said, if we're in a position of economic downturn where the government is really using the unemployment benefits as that economic safety net, they may extend the benefits from 26 weeks to anything they want, usually up to a maximum of 52. Those additional weeks that are above and beyond the 26 that the state provides to you, very likely it's being paid for by the federal government, not coming out of the state fund at this point, but coming from the federal government, from the federal unemployment tax. Okay. Now, I should talk about how this particular project is funded. If you have employees, you need to report your employees and their payroll to your state government, to your state unemployment system. And you will pay a tax based on the wages that you pay to your employees. In Pennsylvania, I could be wrong on the limits right now. I haven't looked at the form in 3 months. But you pay whatever your experience rating is, talk about that in a minute, times the employee wages for the quarter, up to a maximum amount per the year. I believe it's like $9,000 or $9,500 right now. So if you have an employee who makes $8,000, you're going to pay unemployment tax on everything that they make. If you have an employee that makes $20,000, you're going to pay unemployment tax on the first $9,500 that they make, and then you don't pay state unemployment tax on anything above that 9,500. So it would be 10,500 that you would not pay unemployment tax on, which is great. You know, it's nice to have employees that are actually making a living wage. You don't have to pay above that certain maximum level. I talked about the experience rating. Every employer has a different tax rate. What? That doesn't sound fair. Well, it is fair because what the unemployment department wants to do is they want to encourage employers not to let their employees go. Try and keep your employees employed, keep them working. Build up more stock, more inventory, whatever is necessary. Have them do things that are not directly related to production that are going to help you. If you don't lay them off, then your experience rating with the unemployment office is going to show that you're the type of employer that does not take advantage of layoffs and having the state pay your employees. As a result, the tax rate, your experience rate, is going to be low. If you're the type of employer that knows you have a busy 9 months of the year and then a completely flat 3 months of the year, and you lay off all your employees for that 3-month period where you have slow business, then you're going to have a high experience rating because every year you're going to have people in the system collecting unemployment. It's just like this is where it looks a lot like an insurance program, because if you make a lot of claims against whatever type of insurance that you're buying, the insurance company is going to raise your rates because you use the program too much. If you don't have any claims, then the insurance company is going to reduce your premiums because you're not a risk. Same thing goes true here in the unemployment system. If you're the type of employer who is constantly letting people go and letting a state pay them when you don't want to, then your experience rating, your tax rate is going to be high because people collect against your account. If you're the type of employer that never lays anybody off, then your rate is going to be very, very low. Okay, so there's an advantage to you as an employer to not get into a system where you're constantly laying people off and they're constantly collecting unemployment. It's cheaper for you in the long run. But you know, you have to have work for the employees, so I understand why you would want to lay them off. All right, back to the book. Conduct. A claimant may be denied benefits if he or she voluntarily quit the job. Under normal conditions, an employee cannot quit his job. Well, you're not out of work because of no fault of your own. If you decided to quit, it's your fault that you're not working. There's a job available for you, but you just decided you didn't want to work anymore. Under some compelling circumstances, the law will allow an employee to leave employment. Some cases have involved extreme circumstances or instances of sexual or racial harassment by the employee's immediate supervisor. A lot of times what happens is the employer can't change the job requirements on you. So if I was working a job that I was working, getting $20 an hour and working 40 hours a week, so I was used to being paid $800 a week, and all of a sudden my employer said, you know what, we want you to continue working 40 hours, but we're only going to pay you $10 an hour now. So basically cutting my pay from $800 a week to $400 a week, I would be allowed to quit that job because the employer had changed the requirements of my job to my detriment. So I would be allowed to quit that job and collect unemployment. Same thing if the employer all of a sudden said, okay, yeah, I know that we hired you to work and you've been working for the last year at our location that's a mile from your house. Now we want you to work at a location that's 100 miles from your house, and we expect you to make that commute every day. Once again, that's a whole change in employment circumstances. You would be allowed to quit that job and still collect unemployment. Now, once again, you're not going to be ahead of the game. You're going to be collecting less money, but you have the opportunity to have that cushion while you're actually looking for a new job. Let's see, there's a case in here, architectural testing versus Unemployment Compensation Board of Review. The The employer had established a substance abuse policy which stated in pertinent part, use, possession, or distribution of alcohol or illegal drugs or the illegal distribution of illegal drugs is not tolerated on company property, in company vehicles, or at any job site. Any employee aware of the suspicious abuse, this policy is obligated to report the issue to management. What do we have here? We had an employee that was discharged for failing to submit to a drug test. He applied for unemployment compensation. His claim was denied based on the Section 402 of the Unemployment Compensation Law regarding that. The claimant appealed the decision, and the unemployment referee affirmed the denial of benefits. He then appealed to the Unemployment Compensation Board of Review, which reversed the referee and granted benefits. The board held that because the employee's substance abuse policy, employers did not provide for disciplinary action for an employee who refused to submit a drug test, that did not make him guilty of willful misconduct. So you have to be careful what your employee manual says, those types of things. There are multiple levels of review or appeal available. The first thing that happens when an employee is terminated and wants to apply for unemployment, you have to go through the process of filling out a form, applying for the benefits. In the old days, you had to go and stand in line at the unemployment office. They'd give you a form, you'd fill it out, you'd give it back to them. They would then send by mail the part of that form to the employer, asking whether the information about the separation from service was correct in there, or whether the employer wanted to fight the unemployment, saying that you weren't entitled to benefits. In the old days, this could take quite a while. And what would happen is you would qualify for benefits after your second week of unemployment. And if the employer didn't respond to the questionnaire, you would just automatically get your benefits. And then what would happen is if the employer would then at a later date put in the fact that they were fighting your benefits and that you were not entitled, then your benefits would stop and the state would say, oh, by the way, you owe us money back. In today's world, everything's done electronically. It's done very quickly. You apply for benefits online. You just go to the state unemployment benefits website, fill in the form there, fill in your employment history, say which employer let you go, why are you unemployed, what's the reason for your termination. They will then email the employer asking for information with regard to your earnings. Of course, they have your earnings because you've been reporting them for tax purposes anyhow, but they're going to ask for your earnings, and they're going to ask for the reason for the termination from service. If the employer disagrees and says that you left for reasons that make you disqualified, then the unemployment department will not grant you benefits. They will be denied based on what the employer says. You have the ability to appeal that denial of benefits, and that appeal would go to the an unemployment referee. For those of you that had me for business law, you know that we talked about administrative law and various ways of adjudication of things inside of government agencies. This is a really good example of the judicial action inside of an agency, with the state unemployment department being the administrative agency. They made the determination that you were not eligible for benefits. You appeal that denial of benefits. Well, you don't get to be in front of a judge. You get to be in front of somebody who is administratively part of the department that you are fighting. So this would be an administrative law judge, an ALJ that works for the Department of Unemployment. They would be considered to be a referee, is their real title here, and they would hold a hearing. It would be a conference room. It's not going to be in a courtroom. They're very, very informal. Be a conference room with the referee sitting at the head of the table, the two parties sitting on the opposite sides of the table, and then what would happen is the the referee would ask the claimant why they believe they're entitled to benefits. Then he would ask the employer to provide whatever testimony or proof showing that the employee was not entitled to benefits. There would be an opportunity to cross-examine the testimony of the other party, all done very informally. Normally, lawyers are not even involved in this process if you're smart enough to be able to handle this on your own. Like I said, I did a lot of this as my pro bono work, where I would be at the hearing. The unemployment referees hated to see lawyers there because lawyers tend to make this process longer, because we tend to want to really make our point and do things as if we're in a court. That was one thing that I learned in this process, of how not to irritate the referee. Anyhow, let's assume that you lose at this level, whether you're the employer or whether you're the claimant. If you lose in front of the referee, you get a chance to appeal again. This would be now to be appealed in front of the Unemployment Compensation Review Board. Okay, so the decision of the referee would be reported up to this board that's also a part of the unemployment office. It'd usually be 3 people that would be on a panel that would hear your appeal. Most of the time, this is not done in person. Most of the time, this is just done with paperwork, where the referee would, of course, list the rules that he thought were being applicable to the claim, how he believed the facts were fit to the claim, and how he decided the case. If you believe that the referee made a mistake of law, that they had chosen the wrong law to apply, you can put in a brief, writing saying that you disagree with the decision because the law was inappropriate, or the application of the facts to the law were inappropriate. You can't give new facts or anything like that. The Unemployment Compensation Review Board will then review the case and either uphold the referee's decision or reject the referee's decision by reversing the decision. That's not the end of it. You still have the opportunity to appeal directly to the actual head of the agency. So that would be the department, the head of the cabinet, Department of Labor. Not sure in Pennsylvania who that would be above that. I've never had to go that high. And in theory, if you did not like the decision of the actual head of the agency, you could then appeal in Pennsylvania, it would be the Commonwealth Court, which is the one of the 2 intermediate appellate courts prior to the Supreme Court. So there's a multi-layered system here that you can apply or appeal your loss. At a certain point, you have to realize that you're spending a lot of money because you're paying a lawyer to get through any step above the referee. And how much how much really is at issue here, as for unemployment benefits? You may end up with collecting $10,000 worth of benefits if everything goes your way. Do you want to spend $8,000 in legal fees to collect that $10,000? It's probably not worth it. The company, the same thing. This is going to affect your experience rating, but the experience rating is only going to change by a portion of a percent. Yes, that's going to increase your tax, but once again, the amount of money that you are at risk for here is not unlimited. There comes a point where you're not going to appeal it to the Supreme Court. It just doesn't make sense. It's not economically viable for any of these cases to get that high up into the appellate system. The path exists. You're allowed to do it, but in the real world, it doesn't happen. Yeah, at a certain point, people go, okay, I guess I lost. All right. That's the end of unemployment. I guess I could give you a war story of a case that I had when I was working for the communications construction company, and I was the executive vice president. That made me the number 2 man in the company, right behind the owner. I was brought in because I had past experience with the company. I had my law degree. I had my business degree. I was a very unique employee to add to the mix. I loved the job. I made good money. I traveled a little bit more than I wanted to. I had a company car. I had a company credit card. it was kind of an interesting life for a while, but the travel became kind of oppressive. Anyhow, when I was installed as the number 2 person in the company, that displaced somebody who was already the number 2 person in the company, that then became the number 3 person in the company, and he had to report to me, and he didn't like it. And as a result, he decided that he was going to exact his revenge on the company by stealing from the company. What he had done is he had decided that he was going to, we had some subcontractors that did some construction work for us, and then we billed our customer for the subcontractors' work. They were doing basically the same as our employees, but they were separate companies. What he did was he pressured some of these subcontractors excuse me, to put in false invoices for their work, which then caused us to give our customer false invoices for work that was never done. But what he would do is he would then, because the subcontractor never did the work, they weren't entitled to the money. So he was having them put in the invoices for their work and then having them give him the money that they earned. There was a lot of fraud and a lot of theft and a lot of bad stuff with what he did. It became an interesting test for me when the other managers discovered that he was doing this, and they came to me and they didn't know what my reaction was going to be. They were concerned that I wasn't going to take their word or I wasn't going to care. But the other managers brought to me the fact that this was going on, and they said, "What are you going to do about it?" And I said, "Well, we have to investigate it, make sure that it's true before we take any kind of action on it. But if these allegations are true, he should be fired." And so we did the investigation. I talked to the subcontractor. He was concerned that we were going to take disciplinary action against him because he was indeed turning in fraudulent invoices. But what he did was he showed us all of the fraudulent invoices that he had turned in, and then he showed us all of the payments that he had made to that other manager of our company. So we knew that he didn't personally get any advantage for having turned into bad invoices, that everything was indeed paid to the other manager, who was not a very smart person, because he took his kickbacks. He allowed the subcontractor to write him checks for his illegal activities. So we had an audit trail. It was very, very strange. I fired him. And this was in the state of New Jersey. It wasn't even Pennsylvania. This was New Jersey. And New Jersey's law was that if you could prove that the person was fired for either cause or willful misconduct, that they would not collect unemployment. Cause is, you don't have to even worry about willful misconduct for certain things, like drug use, like violence if you have somebody who attacks their boss, they should be fired. That it shouldn't be given a warning, and you should look in the manual. You're not supposed to beat up your boss. No, that shouldn't, it should never happen. Stealing from your company is one of those things that you don't get 2 chances. You don't get a warning. If you're caught stealing, you're fired. Plain and simple. That's cause. Okay. He was caught stealing, and I fired him. He applied for unemployment. He also sued us and cost us a tremendous amount of money in legal fees. But he applied for unemployment, and I objected to his receiving unemployment, saying that the reason he was fired is because he was a thief and he was stealing from us. In Pennsylvania, that would have been the end of the story. But in New Jersey, because it's New Jersey, that is good for 8 weeks. After 8 weeks, they're allowed to collect unemployment, even if it was willful misconduct, unless the reason that they were fired was a crime. Well, theft is a crime. The fact that we had decided not to press charges against him, but just to fire him, didn't change the fact that it was theft. So then I had to make my claim, claim, I guess, to the unemployment department of New Jersey that he was fired for theft, and I could have pressed charges against him. So what he did was indeed a crime. They did find in my favor, saying that, yeah, he should have been fired and he is not entitled to benefits. Really made him angry. He did threaten my life on 1 or 2 occasions. You do take those seriously when they come from New Jersey. Anyhow, that is one of my war stories about the unemployment system. Any questions about unemployment, how it's funded, what's necessary in order to collect, how an employer can get out of making, prevent an employee from, from collecting, those types of things? Questions? Okay, then we'll move on. The next thing in the chapter is workers' compensation. Workers' compensation is another one of these programs that is basically what we'll refer to as a welfare program, where because it's considered it, what it does is it gives benefits to an employee who is in dire straits, who has problems and needs to be able to make ends meet. Okay. So this is for somebody who is injured on the job in the course of employment. Now, there's a lot of stuff that's out here. We can go through, weeks and weeks and weeks of studies of what does it mean that you were injured in the course of employment. We'll talk about that in a little bit, but I want to talk about the history of the workers' compensation laws. Once again, this is a state-driven system. There is no real federal workers' compensation law. So each state has its own workmen's compensation law, and what it does is it pays an employee that was injured at work. So if you are doing your job and you are injured, the employer takes on two responsibilities. The employer will be responsible for your medical bills. Okay, you're working at the job, there's some sort of a malfunction in the machine that you're working on, a piece comes flying out and it breaks your arm. You're going to go to the hospital. You're going to have a doctor look at it. You may need surgery. Hopefully it's just they need to reset it, put it in a cast. You need to give it a rest for a certain period of time. Maybe you're not able to work for a certain period of time because your job involves using that arm as part of the function of what you do. So the employer has two responsibilities. One, they have to pay your medical bills. And two, they have to pay you for the time that you miss from your job. Okay, so once again, this is a salary replacement benefit. So if you're going to be hurt and off work, the employer is supposed to continue paying you. Now, this generally doesn't happen directly, unless you're really dealing with a very large company that has a very big pot to pay money out of. Most of the time, this is done through commercial insurance. Okay, so what you will do is you will end up buying insurance from some insurance company to cover your workman's compensation liabilities. Okay, so let's talk about the history as to why this exists. Those of you that had me for employment, or excuse me, for business law, I talked about it there. This is a situation where we had the defenses to negligence rearing their ugly heads. You have to look at everything, and I said this, I believe, last class, you have to look at everything in the law based on where you are in history. Because when I was in law school and I started reading Supreme Court cases regarding certain things, I was astounded that at one point they would go completely to this, to the left, and at other times they would go completely to the right, and it made no sense. They didn't seem to be very consistent going back and forth. But the reason for that is it was a very much a it was what would happen, we're talking about the early 1900s. And if you look in history, the early 1900s, you have a situation where we have big business starting to really fire the economy of the United States. Prior to the early 1900s, the United States is just this backwards country. Europe controls the world. England's got its empire. We're just sort of this outlier out there that nobody really knew what to make of. The United States was kind of a separatist country. We didn't want to be part of the bigger community. We just sort of wanted to be left alone. We weren't a world power. Then all of a sudden you end up with these industrial magnates that are just starting to fire the power of the United States economy. You have Carnegie and Steel. You have Getty and oil, and you've got you know, Morgan in finance, and you've got, you know, just the big names that are creating these massive companies, a tremendous economic power, tremendous manufacturing power that was coming out of the United States in the early 1900s. The government liked that. It's like, ooh, we can make the United States a world power. Ooh, we can have an economy that's going to be growing and ballooning, and everybody's going to be rich. The government loved that, and it was reflected in the court system. Okay, what you will find that most court cases that dealt with employee rights in the early 1900s until you get up into that area of the Great Depression, everything went in favor of the company. Why? Because the courts, the government, the administration, everybody wanted the companies to have the ability to grow. We couldn't punish or slow the growth of these big industrial behemoths. Okay, so here's your situation. You work at a steel mill and you have a very dangerous job. OSHA doesn't exist at this point, so safety is kind of one of those things that's kind of an afterthought. And we end up with you getting hurt at your job. You end up losing an arm. Let's say, you know, something bad happens and you get your arm amputated at work. You don't die, but you can't work anymore. Maybe you've become crippled. It's interferes with your ability to walk. You can't walk. You can't do any physical work. Okay, now, is there unemployment out there for you? No, it doesn't exist at this point in history. Does Social Security exist so you can get the disability payments? No, it doesn't exist yet either. So you've got no money coming in. Where's your income? You don't have any. You know, so if you were hurt in an industrial accident, your only recourse was to try and sue the employer for negligence, that they allowed you to get hurt while on the job. I'm going to tell you right now, you're going to lose, because the courts are not going to be very sympathetic to your claim, because you're going to go in and you're going to say, Your Honor, I should be given compensation because the employer was negligent in how they ran the company, allowing me to be injured. Therefore, I think I should get this big lump sum of money, which will take care of me for the rest of my life, and we'll just go our separate ways. The court would say, well, prove your negligence. Well, negligence is that you have a duty, you breached that duty, that you caused injury, that there was a causation between the breach and the injury, and that there was indeed an injury. Okay, so prove your negligence. Okay, there you go. He had a duty to keep me safe. He didn't keep me safe. Okay. Company, do you have any defense? Well, yeah, I got a big defense. It's called contributory negligence. And the concept of contributory negligence was that if you were involved in a negligence action, you were the plaintiff seeking recovery, if you contributed to the injury at all, even 1%, if you were 1% responsible for the injury that occurred to you, complete bar to recovery. A complete an amnesty to the company if you were at all responsible. Were you looking away at the time that the machine broke apart and cut off your arm? Well, I happened to glance over because I was looking to see when the next piece of machinery, the next piece of steel was going to come over. I needed to make sure that it wasn't going to harm me. So you weren't looking at the machine at the time that it exploded. If you could have, if you would have been looking at the machine, could you have moved and not been injured? I guess. Contributory negligence. You shouldn't have been looking that way. You should have been looking at the machine. You don't recover. Oh yeah, you don't like that one? I'll give you another one. Assumption of the risk is another defense to negligence. If you decided that you knew that this was a dangerous activity that you were engaging in, but you decided to do it anyhow, you assumed the risk. Your Honor, I should be compensated because the company allowed these safety bad things to go on and it caused me to get hurt. So judge will say, so you knew that it was dangerous. Oh yeah, there's lots of people who get hurt at work. So you knew there was a danger. Yes. You knew that you could be harmed by going to work that day. Yes. Yet you decided to go to work that day? Well, I had to. I needed to make the money. But you knew that by going to work, you could be injured. Well, yeah. Assumption of the risk. You don't win. So anyhow, this was a tremendously abusive process, and the courts really got stuck into that particular spot. Okay, so workers' compensation is the legislative effort to fix that. Okay, so state legislatures started getting together and saying, here's what we're going to do. We're going to pass laws saying that the employers will be responsible for injuries to their employees while on the job. Okay, so you end up with a situation where give her your boyfriend number. Hey, Marlon, I think you got your mic open.
My fault.
Okay, that's good. So the states decided that they were going to do something about that. So if you were injured at work, you were basically out of work for the rest of your life. No chance of ever getting employed again. How did you eat? There were no social programs unless some charity were to take you in. You would probably starve to death. So this was not a good result. This is not how we wanted society to be. So states started passing workers' compensation laws. So basically, here's what happens. Workers' compensation is a no-fault system. Okay, because of the fact that the employers were basing their defense on the fact that you, the employee, were partially at fault. These new laws came along and said, we don't care whose fault it is. We don't care if it's the employer's fault. We don't care if it's the employee's fault. If the employee was harmed at work, he gets paid. Well, what if it was he was responsible for his own action? Was he at work? Yes. Did he get hurt at work? Yes. Recover. What do you think about that? See, what you give up, though, what you give up by this being a no-fault system is that you are not allowed to sue the employer. So even if the outlook of the courts has changed and the courts would look on your claim more favorably, you now don't have the right to sue the employer anymore because you're covered under the workman's compensation laws. And under workman's compensation, you recover under a no-fault system. It doesn't matter whose fault it was. You're hurt at work, you recover, but you can't sue for the big money. What do you think? Even trade? Maybe. That's the way the system works. Okay, so it's a no-fault system. All you have to do is you have to prove that you were injured at work. So if you are injured at work, prove it. Your medical bills will be paid and you will have replacement income. Once again, it's not going to be complete 100% replacement of your income. It's going to be some percentage. Once again, we don't want you to be comfortable. We want you to try and rehab. We want you to come back and start working again. We don't want you to believe that you're better off staying on workers' compensation benefits. Okay. Workers' compensation benefits awarded to an employee when injuries at work are related. For the workers, typical compensation schemes permit easy access to benefits, relatively simple adjudication of disputed claims, plus the possibility of an additional, perhaps more substantial recovery and related third-party tort action. So if I'm injured at work and I can sue, say, the manufacturer of the machine, as opposed to my employer, I might be able to get a windfall by suing for like product liability from the companies that made the machine that injured me, but I can't sue my employer. For the eligible to be eligible, the employee's injury must be work-related. Sometimes factual circumstances make it difficult to determine whether the worker's injury or illness is really work-related and therefore covered by workers' compensation or falls outside the jurisdiction of the Act. Some examples include injuries intentionally inflicted upon one employee by another. You get into a fight at work. Is that a workers' comp injury? Injuries related occurring when the employee is on the road, especially if the trip began from the employee's home. All right, so I'm going to leave my house. Let's say that I am a on the road salesman, but every day I'm supposed to report to the office first and then pick up my leads and then go out and start trying to do my sales. Let's say that the boss calls me and says, hey, John, on your way in, can you stop over at Perry Supply Company? There's a part that we need picked up. Can you pick it up on your way in? Yeah, sure, no problem. And I get into an accident on my way into work. Is that work related? I was doing something for my job, but it wasn't normally part of my job. Normally, my drive into work from my home to the office is on my time. It's not part of my compensated time, so I'm not working at that point. Does that change things? That's a fact situation. It would be a hard one to answer. Chronic illness, such as lung disease. Yes, sir.
What if you do get paid for travel? Because I know like some people, if they work like over an hour away or whatnot, you get paid time for travel.
Yeah, it depends on whether they just decide to give you the hour as a bonus type thing, or if they're actually paying you for the specific time that you're on the road. I think if they just arbitrarily gave you an hour, then it probably would not be covered. But if they were paying you for the exact time that you are driving, you have a better argument that you would be covered. It's a good question. It's a good question. Chronic illness, such as lung disease, especially if your contributing factors include workplace hazards like dust. If you're a coal miner and you end up with coal miner's black lung, is that a work-related disease? Well, we found out over the years that answer is yes. One of the most difficult issues for the courts in recent years has been in utero injuries to a fetus as a result of the mother's on-the-job accident. Should workers' compensation be the child's exclusive remedy as if the mother's, or should the parents be able to sue for larger damages on the child's behalf? Yeah, it becomes an interesting question. There's a whole lot of stuff. There's a ethical dilemma in your textbook with regarding to in utero injuries. Whatever you like. Let's see, federal preemption of workers' compensation claims. The workers' compensation has been left primarily to the states to administer. The system does brush up against various federal acts for compensating workers for whom Congress now deems or at some time in the past considered deserving of special protection. Railroad workers have long had recourse to the Federal Employee Liability Act. Sailors comes under the Jones Act. Other maritime workers are covered by the Longshoremen's and Harbor Workers' Compensation Acts. U.S. government workers have their own Federal Employees Compensation Act. So understand that there are going to be some employees out there that might fall into other programs. Specifically, if you have some sort of a connection with the federal government, there may be a federal law, but there's going to be some law out there that is going to give you these protections. How much time do we have left? We have 5 minutes left. I want to talk about independent contractors. A lot of employers don't want to have employees for a variety of reasons. It gets expensive to have employees. If you have an employee, you have to pay employment taxes. You have to pay the Social Security match, which is like 7.5% tax you have to pay. You have to pay workers' compensation insurance. So if you have an employee, you have to pay for the insurance. Like I said, it's going to be a commercial insurance. You have to pay unemployment tax to have an employee. So a lot of times what happens is if you have a business where you have particularly dangerous work, your workers' compensation insurance is going to be very expensive. What happens is it's based on the wages that you pay your employees. So the insurance company will charge you a percentage of the wages that you pay as the premium for the workers' comp insurance. Certain jobs are not very dangerous. I'm a lawyer. I don't, workers' comp on a lawyer is not going to be extraordinarily expensive. How am I going to get hurt? How about a secretary, a receptionist? You can probably get a paper cut and get it infected or something like that. So yeah, it's not completely without risk, but your chances of being injured on the job are slight, and the severity of the injury is going to be minor compared to somebody who is working in a very dangerous profession. Now, this is one of those things in that company that I was working for where we did communications construction. We had people climbing telephone poles. They strap on a belt and the spikes under their heels, and they would climb the telephone pole and hang from the telephone pole by their belt while they were doing the work at the top of a telephone pole. Think people fall? Yeah. You think there's a chance to get electrocuted while you're up there playing around by the electric wires? Sure. This is a dangerous job. And as a result, our workers' comp insurance was very, very expensive. Now, we weren't violating the law because we did have companies that did the work and wanted to be subcontractors to us. We had employees that were our employees, and we paid payroll taxes and unemployment taxes and workers' comp for them. But we also hired out other companies to do the work. So we didn't have to pay workers' compensation insurance. We didn't have to pay unemployment insurance. We didn't have to pay Social Security match. But of course, we were paying these people more because they were actually businessmen running their own business. I don't believe we were violating the law, but there's a lot of employers out there that try to get out of paying these expenses by claiming that their employees or their workers are really independent contractors as opposed to employees. One of the industries that's out there that is particularly adept at doing this, or particularly wants to do this, I had a client that had a tree trimming business. Climbing trees and cutting trees is very dangerous work. And he decided that what he was going to do, the guy who owned the company, he was going to have some of his employees be subcontractors, specifically the climber. In a tree cutting business, there are 3 people that come to your house to do the job. There's the boss, who is basically there to collect the money and make sure the work gets done without a lot of damage being done. There is the ground hand, who's completely unskilled, and he's strong back, weak brain. His job is to collect the branches as they fall and put them into the shredder or put them on the truck or whatever. And then there's the climber, the guy who makes the most money because he's doing the skill work and the most dangerous work. Well, in this company that I'm talking about, the owner decided that the climber was, although he was part of this team, he was an independent contractor. He had the ability to work for other people. We didn't control how he did the job, blah, 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 blah. And the whole reason that the guy did this was to get out of paying the workers' compensation insurance, because the workers' compensation insurance was, I believe, around 35%. So whatever he was paying the climber, we'd have to increase that by 35% for the workers' comp insurance on the climber. So as a result, he decided to consider him to be an independent contractor. And these people are not smart enough to realize they're giving up a lot of benefits. And of course, they get hurt. This particular company, the climber died. And there's a massive lawsuit going on right now, which has bankrupted the company, has bankrupted the guy that owned the company, all because he decided he was going to try and make his prices cheaper and not pay workers' comp insurance. And it's going to be a massive problem once this lawsuit is settled. We'll talk more about the difference between an independent contractor and an employee as we go through the course. But this is one of those areas that there's fraught with abuse, where people are trying to make people contractors when in fact they are really employees, either because they don't want to pay workers' comp or they don't want to pay employment taxes. All right, that's it for today. I've run out of time. It was all exciting, I thought, very useful stuff. If you're going to be running a company, you need to know a lot of these things. Unless there's any questions, that's all I've got for today. We will be meeting on Zoom again on Thursday. I don't have any indication as to when my son is actually going to be discharged from the hospital, although he's making very good progress at this point. So we are seeing an ability to get out of here and eventually go home, but we don't have any date for that to happen yet. So Thursday's class will meet on Zoom again. And unless there's any other questions, that's all I got for today. Nobody? All right. See you guys on Thursday. Bye-bye.